My Lords,
Yes.
I appear with Mr. Riaz Cicharan for the appellant, and my learned friend, Mr. Benton, appears for the respondent. My Lords, our position is that there are two issues for consideration. Those two are the manner in which the duty under Section 16 is to be enforced, and the second one, the adequacy of reasons, which my learned friend, Mr. Cicharan, will deal with. I propose to deal with them in that order, unless the board suggests.
No, that seems very sensible.
Yes. Okay. Now, my Lords, the decision of the Court of Appeal, in essence, they adopted the decision of in Sanjeev Rangarib case, which my Lords would find at page 271. And the effect is essentially that the Court of Appeal position is in order to compel reasons under Section 16, you must first launch an attack on a substantive attack. And only when you get leave in that substantive attack, you can compel reasons. It is our position that the Court of Appeal fell into error in this construction of Section 16. And to appreciate that, one must look at the purpose of given reasons. And we've referred to in that regard, we've referred to the Privy Council decision in Stefan and General Medical Council. Unfortunately, it is not in the bundle, for which we apologize, my Lord. But we have quoted from Lord Clyde, stating as follows: the advantages of the provision of reasons have often been rehearsed. They relate to the decision-making process, in strengthening that process itself, in increasing the public confidence in it, and in the desirability of the disclosure of error where error exists. They relate also to the parties immediately affected by the decision, in enabling them to know the strengths and weaknesses of their respective cases, and to facilitate an appeal where that course is appropriate. Further, Justice Devines and the Trinidad and Tobago High Court, in the matter of Radio Vision Limited, and Magistrate Marcia Marie and another, on the issue of Section 16, and my Lords will find that at page 643. Yes, 643, paragraph 17, Roman numeral 3. You will see where he says, although it has been argued that the reasons were not required in order to raise a challenge based on error of law, the fact is that by Section 16 of the Judicial Review Act, the applicant was entitled to request from the intended defendant a statement of the reasons for her decision. And in my opinion, it was prudent for counsel for the applicant to make every effort to obtain her written reasons before filing an application for judicial review of her decision. And then again, if in the decision of Chester Polo and the Public Service Commission, and this is a judgment of Justice of Appeal Dean Amora, who was then in the High Court, the same judge who delivered the decision which is under challenge in these proceedings. And my lords will find that at page 402. And you would see paragraph 6 on page 402, it begins there. And it says the court finds it necessary to distinguish Big Ben, in which the minister had no statutory obligation to provide reasons. The learning set out in Irmakov asserts that the purpose of reasons is to enable the recipient to know whether to challenge the decision. It is the view of the court that the rationale for section 16 is the same. The aggrieved subject of a decision is assisted in determining whether or not to apply for judicial review by reasons at an early stage. For this reason, the applicant may seek to enforce the provisions of reason at the application for leave for judicial review. And then she says, it appears to me that the provision of reasons when the applicant has already obtained leave to apply for judicial review and the application for judicial review has already been made is to defeat the spirit and intention of section 16.
Yes, she seems to be saying it's putting the cart before the horse.
Yes.
Yes.
And then I would like to take the court to the board to page and also civil appeal number 274.
Which page? Electronic page?
Yes, this would be page 587 and 588, paragraphs 31 and 33.
And the case is called?
Primna Jilal and the Attorney General.
Gial and the Attorney General.
Yes, so I'll take my lords to paragraph 31.
And this is in the
Trinidad and Tobago Court of Appeal.
This is Justice of Appeal Raj Kumar.
Yes. And what we are submitting is Justice Raj Kumar is here recognizing an independent right to bring judicial review proceedings to compel reasons under section 16. So at paragraph 31, with respect to 3, an application to the High Court for an order compelling the Chief Magistrate to provide her reasons if she refused to do so. The respondent makes the same error of ignoring the fact that the Act itself contemplates that the reasons would not be kept a secret and would be provided because of an effective application could not be made without that essential information. The Act he's there is referring to there is the proceeds of crime legislation. And then at paragraph 33, he says, the fact that an application may be made under the Judicial Review Act does not detract from the fact that the Act itself makes provision for an application to be made without the additional hurdles of having to make separate applications under the Judicial Review Act. The alternative of an application for judicial review to obtain those reasons would be both time-consuming, costly, and unnecessary. It would add an extra element of delay and bureaucracy, which is entirely unnecessary, given the provision of reasons is implicit in the Proceeds of Crime Act as a matter of right. So, Justice of Appeal Rajkumar is recognizing here that the appellant could have applied under Section 16 for judicial review under Section 16 to compel the reasons, but is saying essentially that would not have been a feasible option and unnecessary. It would have been unnecessary because the Proceeds of Crime Act itself makes provision for reasons.
Yes.
And then I wish to refer the board to the decision of Brayhead Ascot Limited versus Berkshire County Council and another. Lord Parker, CJ. And my lords would find that at page 311, and it's at page 313 of that judgment.
So the judgment starts at 304, I think, but you want us to look at 313. No, 313 is...
313 is a different case.
311.
311, I'm so sorry.
I'm taking my laws directly to the
passage on which you rely.
Yes.
Certainly. And where do we find it in which paragraph on that page?
So at the last paragraph on 313 starts with no doubt.
That paragraph, thank you.
So no doubt such a non-compliance may be and often will be inconvenient for an applicant.
Sorry, 313.
311.
No, 311.
311.
The last full paragraph.
Yeah.
Yes. So no doubt such a non-compliance may be and often will be inconvenient for an applicant. He may find it necessary to give notice of appeal to the minister before he knows the strength or weaknesses of the case, which he will have to meet. However, he could undoubtedly demand, as of right, a statement of reasons, and by threat or effect of an order of mandamus secure them. And it would be strange if the minister did not adjourn his appeal until the reasons had been delivered and considered. And this year, the court was dealing with a statutory right to appeal.
You're working by analogy. You're saying that the judge here says that a request for a statement of reasons can be supported by a mandamus. You're saying Section 16 taken with Section 5
Yes.
gives you the same right.
Yes.
Yes.
And essentially, if I want to refer the court to Section 16 itself, 16.3 in particular. And my lords will find it out.
It's 539.
Thank you. Now, if my lords look at section 16.3, it says, where the decision maker fails to comply with a request under subsection 1, the court may, upon granting leave under section 5 or 6, make an order to compel such compliance upon such terms and conditions as it thinks just. Now, if we look at the wording of that section, it never said that upon granting leave in a separate judicial review proceedings or in a substantive attack judicial review proceedings at substantively attacking the decision. What we say is the effect of this section is what it does because reasons, judicial review application for reasons, are not intended to be a long and drawn out process because it is in fact a prelude to filing a substantive attack. What the legislature is here doing is in effect giving the judge, giving the court a power to deal with applications to compel reasons in a summary manner.
But what's the court granting leave for?
Yes, correct.
So, in our application for reasons, which we filed, which is the subject of this decision.
So what's the point of
there's no good. The court would make the order requiring the reasons to be given. So what is the point of granting leave for judicial review? That implies there's going to be a substantive hearing.
Yes, well, you cross the threshold, you get leave, and then once you get leave, the court is vested with a power now to, in an appropriate case, to give you the order for reasons.
But the question I think that's been posed is get leave for what? What is the judicial review application that is given leave?
The application to compel reasons.
But you've got the order to compel reasons, so you don't need a further hearing.
No, so the judge could deal with it summarily. In other words, the judge could grant you leave and then grant the order. Leave and the respondent with the option to either set aside or appeal.
Yes.
Yes.
Well, it has to be leave granted under section 5 or section 6.
Yes.
And
there are, in our application for leave, this application, section 5 and 6 grounds. Because in your application for leave for judicial review, you must set out which section 5 or 6 grounds you are relying on. So in the application, which is before this court, we have set out our section 5 and 6 grounds.
Which were they? I can't recall, I'm afraid.
If I take my lords to...
the application for leave, I think, starts at page 6.
Yes.
And you refer to section 16.
Yes, if you look at page 14. You see the grounds upon which this challenge is based under section 5 of the Judicial Review Act includes unauthorized or contrary to law, failure to...
where are you reading from?
This is page 14.
Yes, paragraph O, page 14.
14?
Yes.
My page 14 doesn't have that.
Yeah.
It's paragraph O, some paragraph O on page 14.
Yes.
Oh, sorry, I'm looking at the wrong page number. I see now, yep.
Yes, well, I mean, insofar as, yes, you've got quite a scattergun of grounds there. But you are treating, are you not, the failure to give reasons as, among other things, a failure to satisfy or observe conditions or procedures required by law.
Yes.
And secondly, you're asserting a breach of natural justice.
Yes.
Could you just have said failure to provide reasons? Would that have been
No,
enough?
but because that is not listed as one of the grounds.
But the grounds are inclusive. It's not an exclusive list,
Yes.
Well, I think it is.
is it?
I think it is. I
Do you-
don't think it says anything.
They have certain grounds.
Section
What does
3
it say?
says,
It says
Section 3
includes.
says the grounds for judicial ruling include the following.
Oh, yes, you're right. Yeah.
So there's a list, and you
Yeah.
select from the list which
Yes.
are applicable to you.
Whether or not it's sufficient to say absence of reasons, you are saying that when you are a person adversely affected by a decision
Yes.
and make an application within the 28-day
Yes.
period,
Yes.
you are entitled, you say, to treat the failure to give the Section 16 reasons as being part and parcel of the decision,
Yes.
and therefore you assert, as I understand it, 5.3c, failure to observe procedures and reasons, and 5.c.d, breaches of natural justice.
Yes.
Yes. So you bring yourself into Section 5 that way.
Yes.
Yeah.
And as I indicated, the statute itself never said that that grant of leave in a Section 5 or 6 must be in some parallel proceedings. It doesn't say that expressly.
Can I just take you back to Section 16 for a moment and ask you about the nature of the right which you say arises from Section 16? It doesn't appear to, in terms, impose a duty on the public body to give reasons. You can make a request for reasons, and if they're not provided, you can ask the court to exercise, as far as I can see, a discretion that you should be given them. It says the court may, upon granting leave, make an order to compel such compliance.
Yes, because it's not automatic. Because before you could get those reasons, you have to demonstrate you were adversely affected. So
Yes.
you can't just apply for reasons. So the court obviously has a filtering
Assuming
process.
you demonstrated that,
Yes.
the right, such as it is, appears to be a right to come to court and ask for the exercise of a discretion in your favour,
Yes.
rather than an absolute right to reasons every time you're adversely affected by a decision.
Yes, but
That may be for two reasons. One is you'd already got the reasons, or it wasn't a case in which you needed reasons.
yes.
And one can think of reasons why the court might think
Yes.
you don't need the order.
Yes. Yes, so it's not automatic. So in an appropriate case, the judge can give you leave and grant the order. But if there's some reason why the judge, in exercising the discretion, thinks you're not entitled to that, well then of course you don't necessarily need, would not be able to enforce those reasons. But the word, and I will just point out to my lords, that the word in Section 16 is sort of tangentially similar to the word in the Brayhead case, in which I referred.
Well, the Brayhead case says that if there's a circumstance where you're entitled to reasons, you can get an order of mandamus
Yes,
under the procedures that then applied, yes.
yes.
How does it work? You say if all you've asked for is reasons and then you get an order giving you reasons, is that the end of the proceeding?
Yes.
If you think there's something wrong with the reasons, you start out all over again, or you amend your claim and
No,
proceed?
No, you get the reasons. You get the reasons. You look at them and determine whether your client has a meritorious challenge or not.
And suppose you think you've got a meritorious challenge, what do you do?
You commence judicial review proceedings.
You have to start a further process.
Yes.
Is that
that
absolutely necessary? I mean, that does seem to be quite burdensome. I mean, could you not go to the court and say, I'm adversely affected by this decision, I have reasons to think that it's irrational or I've been unfairly treated, but I need to see the reasons. You get an order for the reasons, and then you amend your application. That'd be a much more efficient and cheaper way of going about the matter.
The difficulty with that approach is you may not be able to get leave at all. So if we follow what the Court of Appeal construction is, you are entitled to the reasons only when you get leave. But the problem is you may not get leave because you don't have the reasons and you can't put forward a...
Well, that's the cart and horse point, yes.
But the odd thing about subsection 3 is it doesn't say the court may, upon, let's say, the first hearing of an application for leave, order reasons, so that with those reasons it can then decide whether to grant leave. It may, upon granting leave.
Yes. Yes, which means you have to get leave first without the reasons. You have to cross the leave threshold without the reasons.
But it's a very low threshold, isn't it, the leave threshold?
It is a low threshold, but...
So if on the face of it there are no reasons,
Yes.
or you've got a pretty good argument that the reasons aren't really reasons,
Yeah, but it is...
you'll get leave, won't you?
Yes, but
If you're right.
I will demonstrate why it is important that you get the reasons before you file. In the residency application, so there was a previous application, the residency application. His residency, the appellant's residency, was rejected. They did the same thing. They pointed to statutory sections, and we were unable to file a claim. It is only when we applied for reasons under Section 16, and we were given the reasons, we realized that they took into account a letter from a third party in which our client was not heard on. And we were able to apply for judicial review and set aside and quash that decision on the grounds of procedural fairness. Had we not gotten those reasons first, we couldn't get off the ground because we didn't know that they took into account some letter from a company that we weren't heard on. So we would have never gotten leave in those proceedings. We wouldn't have known where to start.
Yes, it's your, you can call it cart and horse, chicken and egg point.
Yes, and as
You need, if you've got a right for reasons for the decision, which prima facie Section 16 seems to be designed to facilitate, and it's saying to you, A, you must be a person adversely affected, B, you must act quickly because you've got 28 days to make the request.
Yes.
Then if you then go to court, the court has a discretion to order there and then at the outset of the proceedings or order the provision of reasons.
Yes.
So your case, as I understand it, it's really a summary procedure that you raise a judicial review saying give me reasons and you get them.
Yes, because this is really a prelude to your substantive attack. You don't want that drawn out process with in a case where it is clear that you're entitled to the reasons. So we are submitting that the judge is vested with a power to grant you leave and order the reasons, compel the reasons, and leave the respondent to either apply to set aside if it was done ex parte or appeal if it was done inter partes. And the next point I wish to submit.
Yes, so you're saying Lady Simra is making the point that the requirement of leave is a low standard. So if the court were of the view that the decision maker had told you all you needed to know, then the court would not grant leave. They just say, well, no, there's nothing, you don't need any more, you don't get leave.
Which was what happened in this case. the High Court refused us leave because they found that what we got
Was enough.
on the deportation order was in itself sufficient.
So you're saying there's nothing in section 16.3 which prevents you seeking a judicial review for the purpose of getting the reasons?
Yes.
The Brayhead mandamus equivalent, as it
Yes.
were. And if the court is inclined to think that you're entitled to reasons, it therefore grants leave and issues there and then an order compelling the provision of reasons.
And if the respondent is not satisfied with that, they can then challenge it by means available to them.
Well, I mean, if the public authority, the decision maker,
Yes.
would be faced with an order compelling
Yes.
the provision of reasons.
Yes.
But you say that reading section 16 with several of the grounds of section 5.3, you have a self-standing entitlement to go for a judicial review to get reasons.
Yes.
I understand your position. Thank you.
And the final point I wish to make is that if we adopt the construction of section 16 as indicated by the Court of Appeal, then this would presuppose that your substantive attack will always be by way of judicial review. But what if your substantive attack might be a statutory right of appeal, in which case there's going to be no substantive judicial review, as in the case with Brayhead. In Brayhead, the reasons were required for a statutory right of appeal. So there was never going to be any substantive attack on judicial review.
Here there isn't a statutory right of appeal, but you're talking about the broader
Yes,
position.
just in the construction of section 16, it would not, it would,
I see the point.
yes, it would limit section 16. Those are my submissions on that issue. My learned friend will deal with the adequacy of reason.
Thank you very much, Mr. Rundgren.
Just before you leave that, there is authority, is there not, against the position you're saying is the position? That's right, isn't it?
Yes, well, the authority against what I'm saying is
Ramgarib.
Ramgarib, yes.
Yeah, okay.
A decision of Budu Singh,
Right.
Justice Budu Singh in the High Court, who
Yeah.
was the judge in the Court of Appeal who
Yes.
Yeah.
Ramgarib was adopted as the correct answer by the Court of Appeal in this case.
Yes,
And you're relying also on an academic commentator, Dr.
Professor Andy
Ventos.
Ventos, now a judge of the Eastern Caribbean Court of Appeal,
Yes, indeed.
in which he is indicating that it provides a standalone right to compel the reasons.
Yes. Thank you very much.
Thank you.
Mr. Sisharam.
My lords and my lady, the deportation order can be found at electronic bundle page 31 and reads, Yonggao Pan, I have reached a decision that you may not enter or remain in Trinidad and Tobago for the reason that 1. You are neither a citizen nor a resident of Trinidad and Tobago. 2. You are a person described in section 8(1)P and Q, as well as section 9(4)C, F, and K of the Immigration Act, Chapter 1801 of the Laws of the Republic of Trinidad and Tobago, which state, and it recites the sections below in the deportation order. I refer to the case of Poyser and Mills arbitration, which can be found in electronic bundle page 654, and in particular, the paragraph that starts on page 659 in the electronic bundle. May go J, and page 659, at the top of the page, it starts, it is a very difficult matter to say whether that is properly to be treated as something wrong on the face of the award. I am bound to say this, and again, I do not think that it was altogether disputed by counsel for the landlord, that a reason which is as jejune as that reason is not satisfactory. But in my view, it goes further than that. The whole purpose of Section 12 of the Tribunals and Inquiries Act 1958 was to enable persons whose property or interests were being affected by some administrative decision or some statutory arbitration to know, if the decision was against them, what the reasons for it were. Up to then, a person's property and other interests might have been gravely affected by a decision of some official. The decision might have been perfectly right, but the person against whom it was made was left with the real grievance that he was not told why the decision had been made. The purpose of Section 12 was to remedy that, and to remedy it in relation to arbitrations under the Agricultural Holdings Act 1948. Now, Parliament having provided that reason shall be given, in my view, that must clearly be read as meaning that proper, adequate reasons must be given. The reasons that are set out, whether they are right or wrong, must be reasons which not only will be intelligible, but also can reasonably be said to deal with the substantial points that have been raised. And in my view, it is right to consider that statutory provision as being a provision as to the form which the arbitration award shall take.
Yes, we're not, of course, here dealing with an arbitration award. We're dealing with an important administrative decision.
Yes, please, my lord. I just referred to the case in respect of the reason should be proper.
Oh, yes.
And adequate. And in respect of the second authority I wish to rely, my lords, is Hunter and Tack, which is found at electronic bundle 458. And specifically at paragraph electronic bundle page 468, so the decision starts at page 458, and the paragraph referred to is on page...
And this is an Australian case from the Supreme Court of Victoria.
Yes, please, my lord.
And you're referring to page 4?
Electronic bundle 468, paragraph 21.
468, paragraph 21, yes.
While the extent of the reasons will depend on the circumstances of the case, the reasons should deal with the substantial points which have been raised, include findings on material questions of fact, refer to the evidence or other material upon which those findings are based, and provide an intelligible explanation of the process of reasoning that has led the judge from the evidence to the findings and from the findings to the ultimate conclusion.
Yes, we're looking here at a judicial decision in relation to a statutory provision, is that right? Section 93 of some act.
Yes.
Yes, please, sir.
So what was the nature of the litigation where the reasons are being criticized? It's a claim for damages from a motor accident, is that right?
I believe so, my lord. My lord,
because when we're dealing with reasons, it's important to know what is the nature of the decision that's been made.
Yes, please, my lord.
It was an adversarial case involving contest of expert evidence and
Yes.
goodness knows what else.
But presumably you're not disputing the proposition that the reasons that must be given depend on the context, and how specific and detailed those reasons would have to be will be fact specific, will it not? It depend on the context.
It will be fact specific, my lord. My lord, Yes, my Lord. My Lord, the
So docs, I think it was rejected, that proposition.
yes,
So docs district council.
my Lord, the Ramgarb case that was actually quoted by the Court of Appeal, it's found on page.
We're not really going to get very much out of looking at cases, are we, for the reason my Lord Borough's just given? I mean, they say you've got to give proper reasons, but whether they're proper or not, we've got to look and see what in the circumstances was said and whether it's good enough or it isn't.
Yes, my Lord. My Lord, the reason I refer to the Ramgarb case is because it speaks about, in the context of the reasons provided, it actually quotes from Smith's on judicial review as to whether if the reasons recited merely recite a general formula or restate a statutory prescribed conclusion. And the point that we're making in this particular case is that the reasons given, or the alleged reasons given, do exactly that it merely recites a statutory prescribed conclusion. And that is made clear, as I indicated in the Ramgarb decision. It's at page 661 of the electronic bundle. And the reason I refer...
Which paragraph? 661 is the start of the judgment. Which paragraph do you wish us to look to?
Paragraph 26, please, my lords.
26.
Yes, my lord. It essentially says, while I accept that in an appropriate case, such as where the decision maker recites a general formula or restates a statutory prescribed conclusion, see the Smith Judicial Review, 7th edition. The failure to provide sufficient reasons can be seen as being comparable to giving no reasons. This is not such a case. My lords, this was the main decision relied on by the Court of Appeal downstairs. And the short point that I'm making, my lords, is that when one actually looks at the deportation order and the section stated therein, that's exactly what this does. It merely recites a general formula and it restates the statutory prescribed conclusion. And learned Justice Budu Singh, who would have given this decision, who was one of the two judges in the Court of Appeal, in the Court of Appeal decision, says that the failure to provide sufficient reasons is comparable to giving no reasons. And my lords, he did quote from the Smith, and that could be found on page 746 of the electronic bundle.
Page what?
746 of the electronic bundle.
Thank you.
Under the heading, the standard of reasons required.
This is the 2024 edition. Yes.
And 9-137, please, my lord. However, it is clear that the reasons given must be intelligible and must adequately meet the substance of arguments advanced. It will not suffice to merely recite a general formula or restate a statutorily prescribed conclusion. What was the context of that? Because this is talking about meeting the substance of the arguments advanced, but we're concerned with an administrative decision. It didn't meet the substance of any arguments advanced. It was a decision based on a legislation that entitled the minister to deport in prescribed statutory circumstances. Yes, my lady. My lady, what we're saying is that based on the actual order and the sections contained in the order, it doesn't meet any threshold because it doesn't deal with It doesn't give any reasons in terms of evidence, or it doesn't state any facts. All it does is just recite the sections in the statute.
Well, I can see it's very terse, but let's take a couple of examples. Let's look at section 9.4, paragraph F and paragraph K. Now, as I understand it, the appellant would have been admitted to Trinidad and Tobago and would have a certificate under section 9.2 of the Immigration Act. Is that right?
Yes, please, Your Honor.
It is. And what what is being said in 9.4F and K? In 9.4F, it's been said that certificate has expired, so that in effect he is an overstayer. And in K, it is saying that he's broken some terms in that certificate. Now that might equally be the overstaying. But I think the case that would be put against you, and the case that found favour below, was that the appellant would know the terms of his certificate under section 9.2, and he would know if he was an overstayer or not. What is your answer to that suggestion?
My Lord, it would be within his knowledge, but what we're saying is that if one were to look at 9.4 K, in terms of the conditions of the certificate, bearing in mind that the terms and conditions weren't specifically stated in the deportation order reasons, which terms and conditions would he have breached, for example, and what evidence did the minister rely on? Was there a report, for example? So,
before we get there, 9.4F says that he has remained in Trinidad and Tobago after the expiry of his certificate. Is that something that he could ascertain by looking at his certificate?
Yes, please, my Lord, but bearing in mind that there was also a residency application that he would have made. So section 52, for example, my Lord, it does not say if the minister considered his pending residency application.
I don't think I may be wrong, but I don't think you've lodged section 50 of the Immigration Act. I may be wrong about that, but I do. Let me see.
Yeah, 50, I think these would.
No, I think you stop at 44, at 522.
Are you talking about what was that?
Because I was wondering what section 50 said, but I can get that on the internet.
What condition? Because his condition entry changed. He was pending.
Yeah. So, my Lord, what we were saying is we wanted to know what conditions, because I believe that once he would have filed his application for residency, the conditions would have changed in terms of he would have entered via work permit, but while he was there, he would have applied for residency subsequently. And what it doesn't say is that did he breach any of those conditions under 4F, or what conditions were breached?
They might have been claiming that he was working without a work permit when in fact he had a work permit, or they might have been under various misconceptions, and they relied on a raft of reasons, some of which might turn out to be completely misconceived.
Yes, please, my Lord.
I say reasons of grounds that you may or may not come within.
Yes, please, my Lord. And similarly, 9C has become an inmate of a prison or reformatory. It doesn't say where he was held, that he was an inmate of a prison. Was he convicted of something? Was he not out on bail? I mean, it doesn't. So even paragraph 9C, there are no facts given one way or the next of any of those stated statutory criteria. I think that, and similarly, it's under section 8, paragraphs P and Q as well, no facts have been stated of any kind. And I do think that the respondent has indicated in any event, 8P and Q don't refer to deportation orders at all.
Well, they're conditions for leave to entry, aren't they?
Yes, please, my lady.
Yeah.
But their conditions, if you don't satisfy, you won't be granted entry. Is there something that says that they also represent grounds for deportation if you subsequently cease to satisfy them? Is there a provision that says that?
No, please, my lord.
Yeah.
Is that not 9.4?
Yes, my lady.
Yes, 9.4 there, where permitted. Well,
So, just for context, the other pathway in terms of a deportation order is contained in sections 21 to 27 of the Act. That is special. That is where you have an inquiry, and one is able to present arguments and evidence to the special inquiry officer in respect of a deportation. 9.4 gives the minister another pathway to order deportation order if, in his opinion, certain criteria are met. But what we're saying, my lords and my ladies, is that on the order itself, on the face of the order, it doesn't say anything in terms of what the facts were, what the minister considered, how he came to his decision.
Well, but again, it's a straightforward fact. Was he or was he not in Trinidad and Tobago after the expiry of his certificate? That's something that the appellant must know. And what's the answer?
No.
Yes, my lord.
He was. He was in Trinidad and Tobago after the expiry of his certificate. Is that the answer?
It would have been up. It would have been after the expiry of his initial certificate, my lord. But then he made.
Yes, but what does making his application for residency? How does that alter the situation?
Pending PR. Condition.
My lord, I believe that essentially changed his status pending PR.
Which section of the Act tells us that?
There are some provisions of the UK immigration rules which have that effect, but they may or may not be replicated in Trinidad and Tobago.
I've got section 50 in front of me. Transitory provision.
Yeah.
Sorry?
we were just wondering whether there was a provision to the effect that if you apply to extend your leave or for a different form of leave before your current leave expires, there's a provision in the UK that allows you to stay and regularises the position. But I don't know if that's mirrored by your Immigration Act.
Yes, practice.
My lords and my lady, I think it's just a practice in Trinidad. I don't think there's a section in the Act.
Ah, well, that may not.
But in any event, I mean, if the ground were that your entitlement to be in Trinidad and Tobago by virtue of the certificate that had expired if you had an argument, well, because I've applied for residency, that's not a good ground. You don't need to be told anymore. The minister is relying on the expiration of the certificate, and you can then say, well, that's not a good ground because of my application. I mean, we have to look at the practicalities of this. I mean, what is it that, to take the example of 94F, what more does the minister have to say other than your certificate's expired?
My Lord, just in terms of practicality as well, in terms of his residency application, he did get essentially a recommendation from the immigration indicating that he would have been recommended for residency. So he would have had that sort of expectation that he would have been granted residency.
But that was then
Yes,
departed from.
yes.
So
When was the decision made to refuse his residency? Was that before the deportation, was it?
I think it was in around February 2020, my lords.
And the deportation was March.
and this deportation order is dated 6th of March, so that was after the residency decision application had been refused. So to my Lord's point, is it right then that at the point when a deportation order was made, he had been refused, he no longer had a certificate of entry, he was therefore an overstayer, he didn't have an extant residency application, and he was there without leave?
Can't make any application, he was in prison.
Yes, my lady. My lady, at the time he was in prison. He was detained.
At the time,
time
of
of
deportation? Or was he on remand?
When the order was made, yes.
So 6th of March, he was actually in prison.
Yes, please, my lady.
So that too was one of the reasons why the minister made the deportation order.
Yes, please, my lady.
So he got bail after the deportation order then?
Yes, my lord.
Do we know the date that he got bail, or is that something, a detail you don't have in front of you?
I think it was towards the end of May, please, my lord.
End of May?
Yes.
Ah. So
It wasn't the order wasn't served on him until June. I don't know whether that makes any difference to when.
Well, that's true. Yes, he signed the order on the 8th of June. Well, the minister signed the order on the 6th of March, and he signed the undertaking in June.
yeah.
Yes,
Because
please,
he
my
was
lord.
in prison.
Because he was in prison, please, my lord.
Well, again, trying to look at it practically, at the time the minister made the order in March, he was an inmate of a prison. What more needed to be said as a reason than that?
Well, my lord, in the context that, I mean, he was not convicted. There was no trial. He was there as an inmate, and then he received bail.
Well, I mean, he was simply on remand.
Yes.
You've got the point. But what more do you need to be told? You can then, if you think that wasn't a good ground because he was simply there on remand, and he was, in the eyes of the law, innocent until proved guilty. And I think there was some suggestion somewhere that he might have a substantive defence. What more do you need to do to make a challenge than say, well, yes, I was in prison, but I was simply there on remand, and it is an irrational thing to deport me on the basis that I'm simply on remand. Again, one has to look at the practicalities. As Lord Barrows said, you assess the reasons in a particular factual context.
I'm grateful, my Lord. I want to go through the part with the...
Just so that I can understand this, I mean, is the situation that the Section 9.2 certificate on which he was entitled to be in Trinidad and Tobago, that was a work-related visa, is that right?
Yes, please, my Lord.
And the minister is asserting that that work-related visa had expired?
Yes, please, my Lord.
Yes.
And you've not pursued a rationality challenge to that decision? You've not said it was wrong or unsupported by any evidence? Your only claim is that you don't have enough reasons or proper reasons. Is that right?
Yes, my lady. Not yet.
Well, we're 4 years down the line. When are you going to make your rationality challenge?
When we get the reasons.
When we would get the reasons, please, my lady.
Well, what else do you need to know?
I suppose he could have just relied on the fact he was in prison. If that had been the only reason, you might not have had any basis for making an application, or only ground. But he chose to rely on a raft of grounds, and you may say that if he chooses to do that, you're entitled to know what they are, and not just the fact that you can deduce a couple of them.
Yes.
Because they have.
Yes, I was going to come on to that. I mean, if we go up to 8.1, paragraph Q, any person who, from information or advice which in the opinion of the minister is reliable information or advice, is likely to be an undesirable inhabitant or visitor to Trinidad and Tobago. I mean, you can say, what on earth is that about?
And he might have been relying on that as the critical reason, for all you know. If it had just been the prison, he might not have made the order, but in fact he might be relying on a letter from the employer or something that you didn't know about.
Yes, please, my lord.
And has turned out to give you, so we're told, a ground of review of the challenge to the other decision made.
Yes, please, my lord.
Yes, so I suppose your argument could be that even if you knew all the facts for 9.4c that he was inmate of a prison, and all the facts for 9.4f that the certificate had expired, what you don't know is the weight that was attached by the minister to these considerations compared with other considerations which have not been specified at all, including the one which I mentioned, 8.1q, as to why he's undesirable.
Yes, my lord.
Yes, I see that point.
I'm grateful, my lord. I'm grateful. I want to go through the point with the consent, the directions. The affidavit.
Touch on it briefly.
My lord, just one final point to touch on briefly, and that was the letter that was attached to a submission. We did say in paragraph 35 of our submission that the letter dated the 21st of October 2020 was not in evidence before the court downstairs, and was actually attached to the written submission that was filed.
In the court of.
Sorry, can you give us a page number?
243.
Thank you.
My lords and my lady, if I can just take you to page 35 of the electronic bundle, you would see that the judge downstairs did make a case management order for, and included in it the respondent to file and serve an affidavit in response to the affidavit of the applicant on or before 3 p.m. on the 3rd of February 2021, and the respondent chose not to file any affidavit evidence. Presumably, if the respondent had the letter in October of 2020 and wished to rely on it, they would have filed it in response in support of any further reasons. And further, the Court of Appeal did shut down the abuse of process point in the transcript at the hearing of the Court of Appeal, as stated in paragraph 36. Footnote 22 is hyperlinked to the appropriate section in the transcript.
Sorry, could you give me that reference again, please?
I do apologize, my lord.
No, don't. It's my fault. I was looking at something else.
Well, it's a difficult argument to make because we've given you reasons for a different decision. We don't have to give you reasons for this decision.
Precisely, my lord.
On the Court of Appeal so far.
But what was the reference, sorry, that you...
Oh, sorry, yes. It's in paragraph 36 of the appellant's case.
Thank you.
It's on, which is electronic bundle page. It's electronic bundle page 286, but it's hyperlinked to electronic bundle page 176 is the actual transcript. Just for completeness, it's lines 12 to 36, where the Court of Appeal shut down the abuse of process point in respect of those being different reasons in respect of a different decision. I'm grateful, my lords and my lady, if you have no further questions.
Can I just ask?
Yes, please, madam.
Ask this. Say the situation is that certain reasons have been given that in themselves would appear to be valid reasons for the decision being made, but there are also indications that other factors have been taken into account. Are you saying that you need specific reference to those other reasons in order to be able to mount a successful judicial review challenge?
Yes, we have to look.
Yes, please, my lord, because one would have to consider...
Even if the reasons, some reasons have been given that on the face of it would be perfectly satisfactory
and then
the decision.
In respect of what weight is to be attached to which of the reasons that were purportedly given as well, my lord.
Right, thank you.
But as Lord Burrows says, we know he was in prison at the time. That was a reason. We know also that his certificate had expired, so he was an overstay. Does the minister need more? You know, or you can you're in a position to challenge both of those grounds if there is a ground. What more does the minister have to do?
Well, my lord, we would say that the minister ought to have clarified in each of his references made, each of the sections, what facts he relied on and what he was referring to.
So if the certificate on page 31 had just referred to section 9.4 and had not said anything about section 8, you would say that would have been fine?
No.
Well, my lords, sorry, we would not say that would have been fine either, because he didn't necessarily provide the facts, the particular facts.
What factors were taken into account?
And what factors he took into account in respect of that particular section.
What section 9.4? But
Well,
the fact is, was he in prison? Yes. Had his certificate expired? Yes, you're accepting that. But what more do you need to know about those two?
I'm guided, my lord.
But you may say, I suppose, that if in addition reliance is being placed on breach of terms of the certificate, you want to know what those breaches were.
Yes, my lord.
Yeah.
Thank you very much, my lords, my lady. I just still, first of all, with section 16, propose to deal with it quite briefly, if I may, but just can we just turn up the provision again, please? It's at page 539. And I do wonder respectfully whether, to a certain extent, my learned friend and I may be talking at cross purposes here, because I don't think there's any suggestion by the Court of Appeal that in order to rely on section 16, you must first establish an arguable judicial review on grounds that don't relate to reasons. I think all the Court of Appeal is saying is section 16 doesn't expand the circumstances or categories of cases in which reasons are already required by the common law. So in other words, you receive a decision, and if it is of a type in respect of which you would ordinarily anyway be entitled to reasons at common law, which is most decisions, then you've already got an arguable ground for judicial review under the ordinary natural justice limit. So in other words, what the common law says, my understanding of the common law decisions, they say there's no general duty to give reasons, but reasons will be required where they are necessary to understand the rationale of the decision. In other words, so you can launch an effective rationality challenge to a decision. And there's tons of cases on that, you don't need to go to them. You need to have sufficient reasons to understand why a decision is being made. So that's why the common law doesn't impose a general duty to give reasons, because obviously in some cases you don't need to know anything more, because it will just be so obvious on the face of the decision why it's being made. All section 16 says is if you are faced with a decision that has no reasons, you can first of all shortcut the process by asking the decision maker for reasons. And if the decision maker gives you reasons, then that might be the end of the matter, because you've then got your reasons and you can either go off and put up with the decision, or you can JR it on a substantive ground. If the decision maker refuses or fails to provide reasons, you then have to apply for leave under sections 5 and 6. But you have to apply for leave and get leave on the normal grounds, which may include lack of reasons, but only if your decision is the sort of decision in which reasons are required.
Where does it? What is it that says that you have to rely on some other ground, as well as the failure to comply with the request for reasons?
Well, because it's simply a matter, in my submission, of statutory construction, because what the statute says is the court, upon granting leave under section 5 or 6, in other words, upon a normal application under 5 or 6.
What does normal mean? An application under section 5 is an application for judicial review, and a ground for judicial review could be there's a complete absence of reasons. The decision.
I think you're accepting that.
I accept that.
Yes. So you're saying all the Court of Appeal is saying, as I understand your position, is that Section 16 doesn't give a ground of judicial review in addition to Section 5.3. But you are conceding that if someone is adversely affected by a decision, applies timelessly under section 16, the decision maker fails, then he may have a right to apply for judicial review, for example, under Section 5(3)(c) or D.
Yes. So the case that's relied upon, the Budu Singh, Mr. Justice Budu Singh's decision in Sanjeev that's referred to in the Court of Appeal, that's a decision about a preliminary inquiry where the magistrate makes a decision to set aside a no case submission that previously succeeded. So in other words, the magistrate said, no, we're going to get on with the case. There's a prima facie case to answer in the criminal proceedings. And what the judge was saying in that case is, well, decisions of magistrates in those circumstances normally don't attract at common law or under any statute a duty to give reasons, and Section 16 doesn't provide one. So that's the sort of case in which Section 16 wouldn't bite, because Section 16 doesn't create a freestanding right to reasons in all cases. So you have to already be in possession of the sort of decision that would attract a right to reasons anyway.
At common law?
It dovetails.
At common law?
Yes. So it dovetails. If you've got a right in statute, then you've just got a right in statute. It's irrelevant. You've just got your own separate right. So Section 16 dovetails in that respect with the common law, simply saying that if you've got a case in which there are no reasons, but you say, I need reasons in order to understand the rationale of the decision, that will get you leave anyway. And what Section 6 then does is kicks in to allow the court to short-circuit the process by saying, well, I'm not going to wait for whenever to have some substantive judicial review about all of this. I'm going to order the reasons now. So you get leave, you get the reasons, and then maybe that gets rid of the case. That's what this is all about, this provision. Because if the legislator had intended to create and lay over the top of the common law some new right to reasons in every case, it would have said so first of all. Also, it would be a very strange thing to do, because the common law already requires reasons where they're needed. But you've already got
then what is Section 16 there for, if you say it goes no further than your already existing common law rights?
Well, it serves.
On the face of it, your common law right in a case which cried out for reasons is to go to court for judicial review,
Yes.
essentially requiring the reasons.
Yes,
Is it
so-
just there procedurally, so that it sets a time frame and a procedural moment in the proceedings when you can get your reasons?
Yes, it serves actually two practical purposes. It serves one clear statutory purpose, which is effectively to, I don't think there's any secret in Trinidad and Tobago, my learned friend will probably agree with me, lots of decisions are rendered without reasons. It happens quite a lot in Trinidad and Tobago in different contexts. It's not necessarily a brilliant use of judicial resources to have a ton of judicial reviews saying, oh, please can I have some reasons. So this provision effectively gets everybody focused on a statutory scheme with time limits and time things. And then, but what it doesn't do is enable somebody to file a judicial review asking for reasons in a case that doesn't otherwise qualify for reasons. And there was a reference, I think, somewhere to the Caribbean commentary on this provision. And an analogue was drawn, I think, between a Barbados piece of legislation, the Administrative Act. I don't think we have it in the bundle, but, I mean, the Administrative Act in Barbados, Section 13, says public authorities must give reasons in all cases except those in the schedule that national security and so on. So it's a completely different piece of legislation. So that's the main sort of primary function of Section 16. It just circuits cases. So rather than going to a full hearing and hearing argument and then issuing a quashing order because the decision didn't come with reasons, or possibly exceptionally ordering mandamus so that you get reasons, you just have this quick order saying we'll give reasons, and then if the reasons are good, that'll be the end of it. If the reasons are bad, you can presumably amend your JR and carry on.
Well, can we look at what Justice of Appeal Dean Armourer said in paragraph 44 of the judgment, because I think this is the nub of the section 16 point. This is said, it seems plain to us that section 16 does not confer a freestanding right to apply for judicial review, but the right to reasons is triggered where the potential applicant seeks to challenge a decision under section 5.
Yeah.
You're saying it is a misreading of that to say that there must be a substantive judicial review other than a judicial review saying, I'm entitled to reasons, you haven't given them to me, and that's a breach of natural justice or a breach of a procedural requirement.
It would be a bit bonkers to say in a case where there's no reasons, or you have to go first of all and find some other imaginary reason to challenge a decision, and then we'll give you reasons. I wouldn't make that point.
Well, then read the next paragraph. In the instant matter, the appellant invoked section 16 with no indication that he intended to launch a challenge to the substantive decision to issue the deportation order. Had he done so, pursuant to section 5, he would have been entitled to insist on the provision of reasons. Having failed to launch a section 5 challenge means that section 16, under section 16, is no ground. That paragraph does read as if you have to advance a substantive challenge, but you're not supporting that.
Well, it may just be a matter of language. I would say it is a substantive challenge on natural justice grounds because you haven't got any reasons.
But wasn't he doing that here?
Yes, I say he did do that.
Well, so why
So then they got it wrong, according to well, on that point.
The way that, if you read that paragraph in isolation, I think that's, yes, it's not right, because he said two things. He said, first of all, I want section 16 reasons, that anywhere common law I'm entitled to reasons. And he lost on both of those points. But yes, he did make a substantive challenge under section 5, saying I'm entitled to reasons. And if he'd have got leave on that point, then the judge could have granted reasons under section 16.
And are you saying that the substantive challenge under section 5, where he's relying on reasons, would have to satisfy a judge for leave to be granted, that there was a common law right to reasons?
Or a right to reasons out with the Judicial Review Act, yes. Because it doesn't create a right. This is a procedural piece of legislation.
No, I understand, but I'm just wondering...
This is a procedural piece of legislation. It doesn't in any way try to change the substantive law of judicial review. It codifies the common law test of sufficient interest. It sets out the grounds that we all know and familiar with. It doesn't do anything substantive at all.
Well, I must say, when I read paragraphs 44 and 45, I read them as creating a cart and horse problem, namely that you had to advance a substantive challenge to the decision before you could rely on the requirement of reasons.
Paragraph 47 says our first reason for so deciding, that says was the effect of our interpretation of section 16.
Yes.
So
Yes.
I look to be saying now that
Well, they treat
you've had it because section 16,
Yes. But I think the problem that flows back to something that said earlier in the judgment, that this was the claimant's case properly construed was all about section 16. This was a section 16 case because the natural justice argument was sort of took second place, in other words. So I think the court is saying, look, find the right.
So I understand the minister's position on this matter. If someone someone who is adversely affected by a decision, issues a letter timelessly under section 16 and doesn't get an answer, that is a procedure to shortcut what is otherwise a common law right to reasons. But throughout, he will be fully entitled to come to the court saying, I have this order of deportation against me. The reasons given are inadequate. I cannot decide whether or not I have a substantive ground to challenge the outcome challenge the decision, I'm applying for reasons under section 5(3). That would be sufficient, as far as you're concerned.
Yes, so exactly, and that's all Budu Singh was saying, because Budu Singh, Mr. Justice Budu Singh, in the Sanjeev case, was simply saying, as I read his Lordship's judgment, doesn't create a right to reasons in a case where there isn't already a right to reasons. In that case, just dealing with magistrates. But it can't be right. He gets sacked immediately after hearing, but I don't think it can be right to say that you have to think of a substantive ground without having reasons in order to get reasons. I think I could be forgiven for saying that can't be right.
Well, I certainly think the Court of Appeal's judgment is capable of being read that way.
Well, that respectfully, Muddle, is how I read what they're saying, or if they're not saying that, then it should be constrained to saying that. Because otherwise, you're, in a sense, curtailing the ordinary.
You're saying that even if he hadn't relied on section 16 here, he had a claim for unfair treatment because he hadn't been given reasons, and that was entitled to be heard, whether leave should be granted or not.
Well, he either does or he doesn't.
Anyway.
He either does or he doesn't. And
Yes, well, that's one of the arguments here. But
yes, that's why the door, as it were, for controlling the cases that come before the court is just your ordinary section 5.
But I mean, if you're right, I don't understand why the Court of Appeal dismissed his appeal on the first ground.
Well, because
he said I'm entitled to reasons.
Well, because the judge said you've already got your reasons. That's the first instance, Judge.
Well, that's the other ground.
That's the other ground.
That's the other ground.
Yes.
What about the section 16 ground? Why did they find against him on that ground?
That only bites if you succeed on the other ground, doesn't it? Because you've only got leave in a case where you say section. I see the point. In the abstract, if you just extract the section, I see the point that was made against me. No, I understand that point. Well, actually, section 16 doesn't create a standalone right. That's what the Court of Appeal is deciding, and therefore your case fails. But technically speaking, in fact, your case only fails when you couple together A, no freestanding right, and B, no leave under section 5 on your common law. You have to glue the two together, basically.
So you're not seeking to uphold the
They're not
dismissal.
independent grounds for opposing.
Yeah.
The Court of Appeal is right to say, I think all the Court of Appeal is saying is there is no freestanding right to judicial review on the basis of a failure to provide reasons under section 16, and that is true, that's correct. There's a right to judicial review decisions on the normal grounds in section 5 and 6, and if you get leave, then you can answer.
Yes, but the application was made under section 5, and grounds, including breach of natural justice, were made.
I understand that.
And the Court of Appeal has said our first reason for deciding the application is wholly without merit. What was their interpretation of section 16?
Yes.
It seems they've missed out a point, because on your submission they should have then gone on to say, well, okay, section 16 doesn't give a freestanding right to judicial review, but this applicant is making a claim under section 5.
Well, that's then what they do go on and deal with and say another reason. I suppose rather than using the words another reason under paragraph 47, they should have said the related reason is that actually the deportation order did contain the right.
But there are two issues before us, yes. And you're addressing section 16 in issue 1, and I take it from this discussion you're accepting that if the applicant had a common law right for reasons, then he was entitled under section 5 to come to the court seeking judicial review to get those reasons.
But I think what the Court
And he should have got a section 16 order too as well, probably.
But I think, to be fair to the Court of Appeal, what they are rejecting there is the appellant's primary case, which was forget common law, I'm just entitled to 2 reasons under Section 60, full stop. And that's the submission that the Court of Appeal is rejecting there. They're saying, no, you're not. So I think
He's saying you don't have to look at the content of what I've been given, or I've just got a right to reasons, and you haven't provided the statement.
yes, that's that.
And that's the end of it. You don't have to look at what the substance of the matter.
Yeah. So that's the point the Court of Appeal says is wholly without merit on a pure point of statutory construction.
Yes, I mean,
Then there's a more subtle point, which is, well, more subtle, it's just a different point. Which is the reasons are in the deportation order. And
are you turning to the second?
I am. There's a short answer and a long answer. The long answer is still not that long, but the very short answer is I do rely on section 9(4)(f) and 9(4)(k), inmate overstay, for the reasons I think that will be apparent.
It's 9(4)(c), I think,
Yes,
is
C.
listed as the.
K is the conditions.
Sorry, C.
It's C and F, I think you're relying on.
So, but as against.
I mean, the way the argument is developed is, I think, if the certificate had only given those 2 reasons, the appellant probably wouldn't have much to go on.
Well, he said he would. He still would.
He maybe, but anyway, those reasons. But in fact, the minister chose to rely on a raft of grounds. And the question is, if he happens to hit one that will, had it been his only reason, would have been sufficient, does that exempt him from explaining all the other things he's relied on?
Yes, and that's the argument that
It's not clear why it should. If he has in fact chosen to rely on all those other things, they might, they may or may not have been decisive in that.
Yes.
You only know when you know whether, I mean, if they're all good reasons, you don't get to that point, but some of them turn out to be irrelevant considerations, then you may have a ground of challenge, mightn't you?
I understand that argument, and that requires the long answer. The sort of medium-sized answer is, well, these aren't reasons. 9(4)(c)(f), 9(4)(c)(k). They're grounds of deportation. So I suppose it might be said, well, I do say, well, any one of the grounds will do. So it isn't the case where the decision maker is setting out a ton of different things that he or she has taken into account in order to reach a discretionary decision to deport someone. These are grounds in which Parliament has said, if any of these are ticked, you can remove. And just point of context there, we're using the word deportation, and I'm sure it's clear anyway, but it's really administrative removal. There's no necessary disclosure in any of these cases that you're dealing with someone who has a criminal conviction. So the way the statute is meant to operate, I say, in practice is, well, the first question is whether somebody has leave to remain, to use that phrase. And if they don't, then the removal order follows. And that's what happened in this case. So the appellant applied for resident status. He applied on the 6th of December 2019. Meanwhile, on the 18th of January 2020, his work permit expired. And then on the 3rd of February 2020, the residence application is decided against him. From that point onwards, he doesn't have any leave. And then 3 weeks later, or whatever it is, on the 6th of March, there's a removal. So one just follows the other. So, and moving on to the slightly longer sort of answer, it's not a case, as I think my Lord Legate suggested it might be, of saying I don't have to provide reasons in the deportation order because I've provided them in a separate decision, namely a refusal of the residence application. It's simply a case where in the deportation order, the minister just recites what is the current state of affairs. So he says, look, at the date of this...
It's the fact that he's saying not the reasons why he's refused residence, but the fact.
Now, the reason why the appellant doesn't have leave to remain at that point is because his residence application has been refused, but that's a separate decision that was taken earlier. He's also arrested, charged, and he knew all about all of that factual background, which is a point made by the first instance judge. This is Justice Beeson, because he put it in his affidavit. He said, well, I was arrested, I was charged, I was in prison. So he said, well, okay, fine. You know then why. And what the tricky one is actually is the third ground of deportation, which is breach of conditions. And what I say about that one is...
This is section 9(4)K.
Yeah.
Yes.
Yeah.
So that's the, I respectfully submit, that's the only ground for deportation that isn't self-evident, as it were.
Well,
what about P and Q?
yeah.
Well, this is why it takes us... Can I just march through these provisions?
Yes.
I don't think there's any way of avoiding it, to be honest. So,
Should we cover K and then come back to the Section 8 grounds?
I just think it's worth just pausing just for a moment to have a look at how Section 8 relates to Section 9, because then it sort of becomes clear. If I can just start at 489. Page 489, preliminaries to the Immigration Act. Definition of deportation, as I say, is just administrative removal. Entry means permitted entrance and other persons. And then on the next page at 490 at the bottom, permit means a permit authorising entry under Section 10. That's what the appellant had been granted, a work permit. Permitted entrant means any person permitted to enter under the provisions of Section 9. So Section 9 sets out the various different grounds on which you can acquire a visa, a permit to enter, student, work, blah, blah, blah. And then you get your permit under Section 10. And then on page 491, it's worth just noting the definition of prohibited class in Section 8. And then Section 4 of the Act, Section 4.2, a resident.
Sorry, Section 8 prohibited class.
Yes,
What
so
are you
I'm going to come to Section 8 in a moment.
Person.
But it's that, because Section 8 serves three different purposes, effectively. But I'm just flagging up the definition. And then Section 4.2, a resident is a person who's not a citizen, but has the right to be admitted as a resident. And that includes, under Section 5(1)(b), a person to whom permission has been granted by the Minister under Section 6. So just pausing there are two classes of person that are relevant for the purposes of this appeal under this Act. Permitted entrance, work visas, student visas, visit visas, stuff like that. And then residence, which is an upgraded form of immigration status. So it's a bit like under the EU provisions. If you've been in Trinidad and Tobago for 5 years, economically active, you can apply for residence. Residence and permanent residence mean the same thing.
Okay.
A bit confusing because sometimes it says residence, sometimes it says permanent residence, but actually they're just the same thing. So
Residents are defined in Section 5, is that right?
yes. And it includes a person who's been granted residence under Section 6. And one of the grounds under Section 6, A and B, is the 5 years lawfully resident whilst undertaking economic activity, basically. So that's what the appellant did. He said he came into Trinidad and Tobago in 2006. He had a whole series of successive work permits. The last work permit, and this is where the chronology does become quite important, It's a bit confusing, but his last work permit expired on the 18th of January 2020. As I said, he then applied before that expired on the 6th of September 2019, not for another work permit, but for a residence.
And is there a provision in immigration law that regularises, that mirrors 3C?
Section 3C, the bane of everybody's
Yes.
minds, I think, from memory, but I don't know.
You don't know, okay.
But in this case, it doesn't matter because
It had expired anyway, yes.
Because his residence
Yes.
application was refused.
Was refused,
That's the
yeah.
point.
yes. So, just so we can pick up the chronology. So the 3rd of February 2000. Sorry, I'm going to bring myself out of order. Has everybody, did your lordships, ladies, still have the Act up? Because I just want to quickly deal with, I don't want to jump onto my chronology next until I've just dealt with section 8, which is on page 495. So this sets out prohibited classes of persons.
Idiots, imbeciles, feeble-minded persons.
Yes.
It's a wide range of people there.
Extraordinarily wide in my experience, but yes. And then one goes down to P and Q, which is on page 497. And then you have P, which is persons who cannot or do not fulfil or comply conditions. That people who breach the conditions of leave, basically. And then Q, you have undesirable inhabitants. But neither of these provisions contain deportation powers. They're simply
Refusal of entry.
Yes,
right?
it serves two purposes. One, it's a ground for refusing somebody residence under section 6.2, which is what happened to the appellant. But also, if one looks at section 9 and the wording in section 9.1, an immigration officer may allow to enter Trinidad and Tobago on such conditions the following classes. It doesn't refer to prohibited classes there, but obviously...
But 8.1 says that you're prohibited from entry. That's the start of 8.1.
So you read...
So if you're one of those, they can't let you in.
Exactly. Yeah. You read the two together and you can't let... Yeah. So 8 serves two purposes. One, it's a ground for refusing an application for residence. 2, you can't let somebody in under section 9 as a permitted entrant if they're one of those people. And then section 9, subsection 4, on page 500, C is the inmate. 1 has become an inmate of any prison. F, an A of the stayer. And then, yeah, that's it, those two on that page. And then on the next page, K, breaching terms. If any of that has happened, the minister may at any time declare that such person has ceased to be a permitted entrant, assuming they have an extant visa, and then such person shall thereupon cease to be a permitted entrant. And then on subsection 5, the minister may make a deportation order against any person referred to in subsection 4. The point there is, that's why the minister is saying, well, look, you are a person that can properly be described as falling within the categories of C, F, and K, and therefore I'm making a deportation order. But in my submission, the minister in the deportation order is not deciding any of the facts here. He's not deciding that this person has breached conditions. He's simply saying you are a person that can be described as someone who's breached conditions, because there's already been a separate decision saying that, which is your refusal of your residence application.
So I haven't quite got that last point.
So
he's a person who, in the opinion of a minister, is a person described in one of those, or a person who, and then the last of those, person who has broken.
yes,
So that's a fact.
Yes.
That one.
yes, but it's not. an evaluative. In other words, the deportation decision doesn't decide, in this case, it doesn't decide what those breaches are. Because those breaches have already been decided as a separate anterior decision, refusing his residence application. Because this deportation order simply follows the earlier decision. That's what I say.
But how does the refusal of the residence application give rise to a breach? I mean, there would be a breach prior to the refusal of the residence application, but that refusal doesn't regularise what would otherwise have been a breach. Am I not right? Because the breach is overstaying, is it not?
No.
What is the breach?
That's one of his breaches, but that's F. That's F.
Yeah.
But actually, the breach is actually in the residence decision, I say, which is at 243. So before you get to the deportation decision, in order to remember, my lady, there was an earlier decision on the 3rd of February 2020 to refuse residence. However, unfortunately, that decision was rendered without reasons.
Yes.
So, in totally separate proceedings, the appellant challenged the lack of reasons in that separate decision. And then these reasons were provided on the 21st of October 2020. And if one looks down, that's where the Minister in the deportation decision is getting 81p from.
What is the relationship between the certificate in section 9.2 and the work permit referred to on page 243?
Well, by the time we come to the residence decision, none, because that work permit's expired. What happens is the work permit expires, is then an extant application for residence.
But I mean, is the section 9.2 certificate the same thing as the work permit, or is it something different?
I believe that is your permit, isn't it? Yes.
It
The
is.
same thing, interchangeable.
Yeah.
Okay.
Yes. Well, so this really adds nothing, because the 9.4F ground is the expiry of certificate ground, and this is saying the same thing then?
No, so this is saying something else. This is also saying in Roman numeral 1A, in terms of section 8.1p of the Immigration Act, the applicant did not comply with the requirements of the immigration regulations because he worked for different...
I see, yes, it's the regulation.
Right.
So ordinarily what should happen is you get the decision, and it's at page 100. So this is the decision refusing the residence application, dated 3rd of February. And it's exactly the same thing that happened in the Nikita case that I think we were recently provided with. But anyway, it doesn't give reasons, but it says kindly go along to the immigration office. I think what then happens is you then get served other things, including a deportation order. So one follows the other. You get your leave to remain decision, and then you get your deportation decision. But what happened in this case is because he was an inmate in prison and didn't go to the immigration office, you then have this long delay between the 6th of March deportation order and it being served on him on the 8th of June, which makes them look like disparate decisions, but in actual fact they're just the same department making two decisions that follow each other. One, you're not getting permanent residence. The reasons for that include you breach your conditions. And by the way, here's a deportation order because you're an overstayer, you're in prison, and you breach your conditions. So you're meant to get them together. What happened in this case is they end up coming all different times and all over the place because of the period of incarceration and the need to apply for judicial review to get the reasons in respect of the residence decision.
So,
but are you saying that it's good enough that the Minister has hit the target at least once, and in fact he's hit it twice, and it doesn't matter actually whether the third ground is being properly explained or not, because
that's my primary
yeah.
submission. But if that's not accepted, and you say, well, hang on a second, if you're going around telling people they're being deported for a ton of reasons, you have to justify each of them. I say that he has justified each of them, because in actual fact, by the time this came up for leave hearing, there was a leave hearing in this judicial review claim on the 5th of February 2021. By that time, the appellant had the reasons for the refusal of the residence status, because that was provided on the 21st of October. So the point made by counsel below, and that I repeat here, although I don't present it as an abuse argument, is that by the time Mrs. Justice Peterson refused leave in this case, although the judge, didn't see them, in fact the appellant had in his hand the reasons for the refusal of the residence application, which included explaining to him why he was in breach of conditions. And therefore, if you read that along with the deportation order, you know.
So you're saying that the deportation order should be read as, should be understood as, when it refers to breach of conditions, meaning whatever we've relied on to refuse you residence.
Yes.
Not as any separate, nothing separate from that.
And that ties in because also the residence application decision says you're an inmate, it says you've been arrested, it recites all of these points. So the whole thing sits together now. That is effectively the argument that the Court of Appeal accepted.
yes. So just to make sure, looking at the deportation order in page 31, you say ground 1 is he was a prisoner at the time. Ground 2, the certificate, which we can, the 9-2 certificate, which we can equate with the work permit, had expired. And ground 3, which is paragraph K, is he had broken the condition of his certificate, and that was working when he didn't have the certificate.
Yes.
Which is really the same thing as, in effect, as saying your certificate has expired.
Well, I don't know whether he was working for different employers rather than the one that was stated on the front of his grant of leave. So I don't know whether that was the.
Oh, he worked for various companies in Trinidad without the requisite work permit, so maybe something different. Yes.
But in either way, he has the reasons. So what I'm really saying is it's an impermissible, to use the language, an impermissible collateral challenge effectively to a deportation order when the real target is actually the prior decision to refuse you residence, because the deportation order just follows that. I mean, you don't have leave to remain for all the reasons we've already told you, and therefore you're being removed. And if you challenge the residence decision, now you've got the reasons for that, go ahead and challenge it, but don't.
Is there a possible distinction between ceasing to be a permitted entrant, which is the punch line at the end of section 9.4, which then triggers the deportation power under 9.5, and failing to get a right of permanent residence? Because he originally came as a temporary resident, and all he'd been refused, as I understand the letter at 243, was permanent residence. That still leaves the possibility that he was a permitted entrant who just had failed to get a right of permanent abode.
It could have been.
And it appears that not being a permitted entrant is something which the minister has to declare, and it's only when he makes the declaration that you cease to be a permitted entrant.
Yes, well, this is another. This is another point that I was this morning at 7:30, served with a judgment in a case called Nikita, And the argument was raised for the first time, as I would say, that actually the deportation order is invalid because it's a statutory precondition of issuing the deportation order that you have to first issue a notice under section 9(4) declaring, which there's a ton of answers to that, one of which is, well, it's not a point that's got anything to do with reasons, it's about a substantive challenge to the deportation order on Virey's ground. But the other point is I just don't know whether there's been a section 9(4) notice separately served, because I just haven't
Yeah, I mean, my problem is not simply the apparent need for a declaration in a notice, presumably, that you cease to be permitted, although that would seem to be quite an important procedural protection. If you haven't had the notice, then you're not unlawfully there. But more the point, the distinction between failing to get permanent residence and losing your temporary resident status.
Well, I think the point there is there's two bases upon which you can lawfully be in Trinidad as a non-citizen. One is as a resident and one is as a permitted entrant. And what the Minister is saying on page 31 of the bundle there in the deportation order is you are a person described in section 8(1)p and q. Therefore, you're a prohibited class of person. You can't be permitted to enter or remain. You cannot. And therefore you're being removed. So there's no, I may not have understood your Lordship's question, I apologise if I haven't, but there's no grey area. You're either a permitted entrance or you're a prohibited person. And because as part of the refusal of your permanent resident application, it was said that you was declared already in that decision that you're a prohibited class of person. You're therefore an unlawful entrant or person overstaying. Therefore, you get removed.
I suppose you might say that a deportation order is itself a declaration that you're no longer a permitted entrant.
That was one of the number of arguments. Yes, and then because it says I've reached the decision that you may not enter or remain in Trinidad, is that a declaration under all of those arguments could no doubt be had if ever this case gets to a substantive judicial review hearing. But for present purposes, I say that none of that stuff goes to the question of reasons.
But if you're already in Trinidad under 6 or 5 or whichever of the provisions, then how you can't be a prohibited class for entry reasons. You're already here. And 8(1) is about entry.
I suppose you could be in the position that if you leave, you won't be allowed back in.
Well, that's a different point.
That's a different point, yeah.
But I don't quite understand how 8 works in relation to deportation. It doesn't say entry or remain. It just says entry.
Yes, I see the point. So, yes, so entry is prohibited. That's true. And then,
well, the decision covers entry and remaining, and the undertaking at the bottom is an undertaking not to return. So he seems to be addressing both.
Okay.
So section 8 may indicate why, if he leaves, he can't return, and section 9 addresses the fact that he has ceased to be a permitted entrant.
Yeah.
I think that seems to be the way it works. Is it not? If you look at, I have made the decision that you may not enter or remain. That is the.
That must.
That's the decision.
I think my lady's point there, which is that under which provision is that decision being made? Because section 8 doesn't automatically mean you can't remain.
No.
So therefore, my lady's point, as I understand, is, well, hang on a second. If the minister is making that decision, it must be a decision under section 9(4).
Yeah.
But there's another linguistic problem with 9(4). Page 501 is that the minister may at any time declare that such person has ceased to be a permitted entrant, and such person shall thereon cease to be a permitted entrant. In this case, of course, his permitted entrance status has already expired. I'm not quite sure how a minister actually does declare somebody's...
But again,
we do descend into, I say, matters of substance.
these are matters of substance. And my reading in the light of this discussion is that he's making two decisions. He is saying that you have to leave, and that's a Section 9(4) issue.
Yeah.
And he's also saying you can't return without special permission,
Yeah.
which is the Section 8 issue.
Yes, I see, yes, you're making both. And then I can't say, well, yes, I mean, that may be right. If it is right, it raises certain other issues, because it then becomes a decision. Well, I just still don't understand how can a declaration have an effect that shall thereupon cease to be a permitted entrant in a case where the entrance has already expired. It's difficult to conceive how that can work. So I think the statute would have to be read to accommodate situations such as this, where somebody's leave has already expired, because a declaration under Section 9(4) wouldn't have the effect of thereupon revoking permitted entrance status.
Yes, well, if you look back to Section 9(2), the certificate granted by the immigration officer is expressed to be enforced for a specified period.
Exactly. So if you're in a situation such as the instant where the deportation order is made at a time at which somebody has already overstayed,
Yes.
then how can you apply the wording in Section 9(4)? The minister shall declare that someone has ceased to be a permitted entrant. Such a person shall thereupon that declaration cease to be a permitted entrant. It already ceased to be a permitted entrant, maybe months ago.
Yes, it may fit other grounds of Section 9(4) with which we're not concerned.
Yes, anyway, the language is not perfect.
It's not perfect. But as I understand, your position is that there are 3 Section 9(4) grounds put forward, and at least 2 of them are self-evident.
At least 2 of them are self-evident, but I say that the other one, importantly, was clear to the appellant by the time of the leave application in February 2021. And this isn't an impermissible gluing together of different decisions. One is necessarily linked to the other. And although the first instance judge didn't have the reasons belatedly given by the minister in support of the refusal of residence, the appellant did. And that's what led counsel for the respondent below to say, well, actually, it was abusive for the appellant to continue with his JR in circumstances. Okay, you issued it, you didn't have any reasons in support of the residence application, therefore the deportation decision you say didn't make sense. Okay. Well, that's not right in respect of F and K, but I can see the point in respect of... Sorry, it's not right in respect of C and F, but I can see the point in respect of K. But certainly by the time you get to the leave hearing, you've got your reasons in support of the residence application. You must, by that stage, know what everybody's talking about. They're talking about the fact you worked for the wrong employer or whatever it was. Now, I don't maintain the abuse point. I just say that the claim at that stage fell away because you knew then if you didn't know before. And that's what the Court of Appeal is saying in paragraphs 27 and 47. Don't necessarily need to take my lady onwards to those paragraphs 27 and 47. The Court of Appeal is saying, well, hang on, by that stage you know what's going on.
But your primary argument, as I understand it, is that it's sufficient that one of these grounds is factually indicated. That is, if we just take the simplest, has become an inmate of any prison.
Yes, and the reason why I say that is because if one looks at subsection 5 of section 9, which is at page 501, the minister may make a deportation order against any person referred to in subsection 4. I accept the word may, importance of discretion, but the structure of the Act, I say, indicates that what Parliament has in mind is anybody falling with any one of those above the ground is removed. It's not a wishy-washy sort of discretion that is exercised in the round. Well, you did a little bit of overstaying, a little bit of a breach of this. Maybe I won't remove you. You've either got grounds to remain in Trinidad and Tobago as a resident or a permitted entrant, or you haven't. And if you haven't, you get removed. And there's no grey area here.
So your point is that it won't do you any good, but even if reasons haven't been explained for one of the grounds,
Yes.
That won't be getting them won't help you unless you've got some basis on which you could challenge what would anyway otherwise be sufficient grounds for your removal.
Yes, that's my primary case. But the secondary case, if I do have to explain all of the grounds, then I say they were explained because you have this other decision.
Deportation under 9.5 is quite a step up from merely having, as it were, stayed on beyond the expiry of your permit. You might be appealing a refusal of permanent residence, but if you're deported, you've got no right of appeal.
No. In fact, I'm
just questioning your assertion that really deportation follows as night follows day the moment you no longer have a right to remain. Because it seems to me to step up the severity of your situation from that of somebody who's saying, for example, well, actually, I should be given permanent residence. I want to appeal the decision that I be deprived of it.
I don't think there is a right of appeal. Is the other complication.
I'd assumed there was, because there wasn't anything that said there wasn't.
But he's still there at the moment, I think, isn't he? He hasn't been deported.
No,
and that seems to have followed. Has it because he's challenged the underlying decision not to give him residency?
I don't know.
No, we don't know.
I don't know why the order for deportation hasn't been enforced, but he's fighting a civil claim, I think, as
a civil claim? Or
yes,
a criminal claim?
There's a civil claim of an equitable proprietary claim, and
right.
basically some fraud claim. There's a WFO issued in respect of that is still, I think, in place.
Well, there's a practice here where there are judicial review proceedings on foot that removal won't be effective.
Yeah.
So it may be there's a similar.
It may be something like that. But I think my Lord Brick's base central point against me does remain probably fair, because there may be.
It's easy to think of situations where he's got no continuing right to remain, for example, because he's in a prison, and therefore a burden on public funds, where the last thing the minister wants to do is deport him because they want him to come and stand trial.
But that would be up to the minister.
Of course, but I'm just saying deportation doesn't seem to me to follow as a matter of as night follows day.
Well, entitlement to deportation.
Yeah, sure.
Follows
yes,
night follows.
but in practice.
In practice, there may be reasons why the state would refrain, but I suppose for the present purposes, the question is whether the power, in other words...
You're saying that an attempt to challenge the decision will be futile?
Yeah.
Yes, as long as there's some hook for it, it'll be good enough, I say. But if I'm wrong about that, then you have my...
Can I just ask about paragraph section 8.1q, an undesirable inhabitant? Is that because being in prison he's a drain on public funds? I'm only guessing, but it seems to be consistent with the general thrust of those sections if you read them through. It's not because he may be guilty of something necessarily, because it says prison or mental institution, and it seems to be to do with the fact that he's there at the cost of the state.
Well, that's one of the ones it's hard to say that there has been a proper reason given, sufficient reason given. If you had to rely on that, we don't know why it's thought to be undesirable.
That's the last point I was going to make on this, is a sort of half concession, which is actually, if one looks at the deportation decision at page 31, it relies on you are a person described in 8.1p and q. P we, I think, dealt with, because P, one goes to page 495, P is breach.
Yeah.
So in other words, section 8.1p correlates with section 9.4a.
Yeah.
And then section 9.4f is simply self-standing, but the Minister's reference to section 8(1)(q) is not relevant.
Not?
Relevant because no part of the deportation decision actually relates back to that.
Unless being an inmate.
Yes, but in fact that's not relied upon. I see. No, I won't, because that's simply you either are an inmate or you're not an inmate. But none of the other grounds in section 9(4), if one turns to those, section 9(4), none of them include 8(1)(q), actually. So, although the Minister in the deportation decision says actually you're a person that's undesirable under 8(1) and would be a member of a prohibited class on that basis, it's then not, that finding is not actually relied upon in the deportation decision. Doesn't actually, nothing to relate back to it.
Well, that contains its own little minefield, doesn't it? In the sense that if it's said to be part of the reason for the deportation, but you say actually it's an irrelevant reason because it doesn't come within 9(4), it may be that you can attack the Minister's decision on the ground that he relied upon an irrelevant reason.
In the substantive JR, yes, could do.
But we're not concerned with substantive
merits
JR.
here, no.
But again, I come back to the point that he was making two orders. He was ordering deportation and ordering the person to remain out of Trinidad.
Yes.
And in relation to the first one, section 9(4) is relevant. In relation to the second decision, i.e. stay away, unless you've got a special permission of the Minister, section 8(1) is relevant.
Yeah.
I mean, it seems to me that there are two...
refused entry, one ground for prohibition is enough to refuse you entry, presumably.
You have
The fact that there are two or three others doesn't
you
make
have
any
to,
difference.
you have to be. You are.
Yeah, I mean,
You're a prohibited person.
there's a prohibited person once so, but it doesn't matter whether you're twice prohibited,
No.
Yes.
unless the Minister would be influenced on giving special.
Yes.
Another matter.
So,
I think you need to wind up now.
that's it, I think. I was just checking if there's
Yes.
anything else, but I think unless...
Can I just ask you, there was something in my mind about this particular deportation order following a form that was sort of laid down, as I understood it, almost laid down by the regulations or something like that?
It's Form 19B.
Yeah, so Form 19B,
So it is.
and where is that, what is the provision that empowers that form, so to speak?
Well, I think Form 19B was something that was provided to me by my learned friends for the appellants this morning. Literally, I think in support of a new point, which hasn't actually been developed,
Right.
that you could attack the vires of the deportation order on the basis that you didn't send a Section 9(4) notice. And I think the form was provided probably in support of that submission in the end.
What I'm driving at is there in some sense delegated legislation that is saying this is the way that you provide reasons for a deportation order? That's what I'm sort of driving at.
I think yes, because if one looks at Form 53, which is what's been provided, which is the order for use to make a Section 9(4) decision, and it uses the language of Section 9(4), hereby declare that being a person described in Section has ceased to be a permitted entrance with effect from, and the citation is Regulations 40 something or other. I can't see on the print, but I think that's right. I think these are designated forms. I can't say whether they have to be substantially in the form of Form 53 or exactly in the form of Form 53. I don't know, because I haven't had a chance to look at it. I only saw it this morning, but Yes, but it doesn't say in that Form 53 anything about reasons, as far as I can tell.
Yeah.
Which is the actual answer, I think, to your Lord's question.
Yeah. Thank you.
Lords?
Yes.
If I can refer you to second supplemental bundle, page 19, the Robert Naidike case.
Sorry, I didn't hear that.
The Robert Naidike and the Attorney
Page?
General. Page 19. That would be the second supplemental record, which was filed recently.
Do you mean the case we were sent this morning?
Yes, yes, my lord.
It's a bit late to raise it now, isn't it?
Well, it's just
Probably a bit late to raise it at the hearing altogether, but in your reply, I think.
What are we looking at page 19 of the supplemental bundle?
right, well, what on page 19 from paragraphs 39 to 41, it sets out, basically makes section 9.4, the declaration under 9.4, a precondition to the grant of a deportation.
That is a substantive challenge to the decision, which is not before us today. I mean, this judicial review is a judicial review for reasons. It's
Yes.
not a substantive challenge.
Right, but what I want to refer the board to is paragraph 41, where it says, true, there is no requirement to serve or otherwise publish the declaration. And what the effect of that, there being no requirement to serve or publish the declaration, is that without reasons, the appellant would never know if there was in fact a declaration.
I understand that.
Yes.
Yeah.
And then if I, and in respect of section 9.5, the authority of the minister, the power of the minister to deport under section 9.5 is a discretion, and that discretion must be governed by notions of reasonableness and proportionality. So it is not to say once you, for example, once you became an inmate of a prison, you must necessarily be deported. There are factors that the minister has to take into account, and this is accepted by the respondent in, if you go to the transcript, page 177 of the electronic bundle.
Page 1, this is of the electronic bundle, sorry, yeah.
Yeah.
177?
Yes. So the respondent is submitting, if you look at from line 6, the other thing, my lady, if I may say, if my friend is saying, look, I am not an inmate, and I have never been an inmate, even though you say so in this deportation order, I do not have to tell you when you became an inmate, and where you became an inmate, and how long. That is what my friend is submitting is required. No, it is not. If by saying, look, I've never become an inmate, if you challenge the decision by saying, look, I've never become an inmate, if you became an inmate but you have been granted bail, you are still entitled to challenge the decision or on the presumption of innocence. So the respondent is here recognizing that there may be discretionary factors involved, and on that basis it is important for us to know, in respect of the imprisonment, what factors were taken into account. For example, did the minister consider that the appellant was here for 15 years? Did he consider the nature and gravity of the offense? Did he consider the presumption of innocence? Did he consider the offense as a bailable one, for which he eventually got bail? And did he consider that if there was in place a freezing order, but in certain circumstances, one can apply to be permitted reasonable living expenses and to pay creditors and so on, even if there's a freezing order, which he eventually did and was successful. So we say it is not enough to say you are inmate of a prison.
Well, the reasons don't have to go through saying that he's considered this, that, and the other, and if he's missed something out there, then.
Because if we're challenging on rationality,
it can't be sufficient.
If we look mounting a challenge on rationality or even proportionality, we need to know whether you took into account these factors.
Well, you can raise your rationality or your proportionality challenge simply on this basis. He's relied on the fact I'm an inmate, but he's got the wrong man. I was never an inmate, or there's a presumption of innocence. I'm not guilty. I've been here for 15 years as an upstanding citizen. He hasn't taken that into account. The charge is a very low-level charge.
Well, we won't know.
Why?
If what he has taken into account.
Well, it's merely the fact of being an inmate. That's what the legislation says.
But if he hasn't, I mean, it would suit you if he hadn't taken those things into account, because you'd say, well, it's a discretion, and he has failed to take account of relevant consideration. I mean,
Yes.
I mean, presumably the Form 19B that we have in front of us at page 31 is a statutory form authorised by the legislature,
Yeah.
or in regulations, and I'd be interested to know where we find it in the Immigration Act or regulations. And the legislature has considered that this is an appropriate way to express one's decision.
But the minister is not bound by that, because, as my lords would see, in the residency application, full reasons were provided. So he's not limited to that. It's a matter of fairness and giving the appellant information to enable him to assess the strengths and weaknesses of his case. The next point I wish to make, and further, we need to know also on what basis are they saying, does he conclude that the appellant was an inmate? Because where he was in maximum security prison, it is separated into two sections. You have one for convicted persons and one for those waiting on remand to pending trial. Those waiting on trial and remand are normally referred to as detainees rather than inmate. So it would have assisted if some clarification.
Well, no, it wouldn't really, because if you've got a point there, you've got it anyway. You say he wasn't actually within that ground because he wasn't in prison. It doesn't count as an inmate. Either he does or he doesn't.
In respect of, if I just want to take my lords to the page 3 of the supplemental bundle. And that's the letter from dated October 21st, 2020.
Page 3 of the supplemental bundle.
Yes.
I've got a
Second
form.
supplemental bundle.
No, not second. The first supplemental.
I don't think I've got a first.
I haven't got a first supplemental bundle in my...
Is this the order of the Minister under Section 9.4?
No.
Right.
It's the letter given reasons in the original.
I think it's included in the original electronic bundle, is it?
No, sir.
Well, that's all we've got. So
Well, we have at page 692 onwards, we have a supplemental bundle of authorities.
Yes, that's what, yeah, the authority.
Devungala and Chief Administration Officer.
No, not those. There was a supplemental bundle
Yes.
filed solely with the letter of reasons given in relation to the residency.
Well, that's 243.
That's 243. That's in the.
Supplemental reproduced record.
That's, yes, so you're talking about the reproduced record. Yes.
Yes,
The letter.
yes.
On page 243.
Is that? Yes, I think so.
Okay.
This is 243.
Yes.
Yes, and if you look at item Roman numeral 1A, in terms of 81P of the Immigration Act, the applicant intended claimant did not comply with the requirements of the immigration regulations, specifically Regulation 10, when he worked with various companies in Trinidad without the requisite work permits. Now, I want to take you now to page 78 of the electronic bundle.
Sorry, page
78.
70.
78.
78.
Actually, 79. And my lords would see a table there with a list of work permits and the period. And you would see that up until January 18, 2020, he had work permits. Now, he went into prison in December 2019. So when that work permit expired while he was in prison. So there was no prospect of him working because he was incarcerated at the time. Further,
But what are we to take from that? I mean, what point are you making?
Well, what I'm saying is we were not entitled to assume, because my learned friend says we had these reasons in our hand, and we knew of this. We were not entitled to assume 81P applied to us for this reason, because we had work permits straight up until he was incarcerated, and he never worked after that.
Well, then your answer would simply be, well, he didn't work without work permits. And
What I'm saying is it called for some further explanation, because we need to know on what basis you are saying which companies we work for, so we could properly challenge this. Are you saying our work permits are fraudulent, or what is the reason you are saying that we worked without?
We're talking about an administrative decision, and what you're calling on the decision maker to do is to anticipate the arguments which you might make against his decision and answer them. I mean, in this case, if we work on the basis that you knew that the minister was making an assertion that you'd worked without requisite work permits, you could say that this was a decision based on a false understanding of the facts, because, as at page 79, I had work permits throughout.
Yes.
You don't need to know
The reasons
anymore.
given for the other decision weren't adequate. No.
No, yeah, what I'm saying is that we were not entitled to assume that 8P was applicable to the deportation, because 8P simply didn't apply to us. So as at the date of his application for leave for this matter, for judicial review, yes, we had 8P in our hands, but we could not assume 8P was applicable because we knew that this didn't apply to us. Because we had work permits.
I don't get your point, I'm afraid. I mean, it seems to me that if you knew that the allegation by virtue of section 243 what was that you'd worked without requisite work permits, yes, you were in a position to mount your judicial review challenge to that ground by saying, well, that's a load of nonsense. I did have a work permit.
No, what the ground was is that we've breached the terms and conditions.
Yes.
No specifics were given. My learned friend is submitting that because we had this in our hands as at that date, we would have known the grounds. And I am saying we were not entitled to assume this applied to us. We were entitled to assume there must be some other ground or some other
The
reason.
minister is saying it in that letter. He's saying in clear terms,
Yeah.
It applies to
it's
you.
about working for companies in
Yes.
breach of Regulation 10. You can challenge that and say he's wrong.
Yes, but that was in respect of the residency. This letter emerged in respect of our.
That's a separate point, isn't it?
Yeah.
Yes.
You may be able to make the point that they are so separate that one can't apply reasons given in one to the other.
No,
But on the assumption that they are in some way linked,
Yeah.
which is the case put against you,
Yeah.
it's not clear to me what point you're then making, because you've got clear, specific information given, directed to your client, and you can challenge that as you may wish.
The simple point is the breach and the breaches and the deportation order. One of them sets out breach the terms and conditions. It doesn't specify what terms and conditions. So we don't know. But my learned friend is suggesting, the respondent is suggesting that we ought to have known because we received this letter in the previous proceedings. And previous, I am saying we must be entitled to assume there must be some other reason.
Well, why?
That you're saying we breach
Why?
the terms
Why?
and conditions.
No, why?
Because this is not applicable to us.
No, well, in which case you make a challenge. I mean, it's nothing to do with what you assume. The minister has put his flag in the ground. This is you are a person who has worked without work permits, and you are in a position to say in a judicial review that is completely incorrect.
Well, then that would mean that we were, when the minister says we breached the provision of 9.4, we breached the terms and conditions, is it then that we were supposed to assume that this is what he was referring to?
Well, either they're linked or they're not. That's one point, isn't it?
Yeah.
If they're not linked, then we forget about this letter. If they are, then you know the reason.
Well, we better move on. You've got 1 minute left.
Just to clarify, I think the respondent has been suggesting that deportation will automatically follow when you are refused your permanent residency, and that is not in fact the case. If you refuse permanent residency, you're still a permitted entrant, unless you are declared under 9.4 not to be a permitted entrant. So you have a range of options. You can apply for an extension, you can apply for a minister's permit, you can apply for another work permit, and so on. None of which he could have done, obviously, because he was incarcerated. Now, the expiry of your stay doesn't automatically mean you will be deported. When you overstay the time you are permitted, you become susceptible to being deported. But it is only triggered by the minister's declaration. So you're really at risk. You're staying at your own risk, so to speak. But the process must be triggered by the minister's declaration.
Which would be, if there was no such declaration,
Yes.
on your submission, that would be a substantive ground to judicially review the deportation.
Yes, but we won't know if there was a declaration. Unless the minister had, in his reasons, told us you cease to be a permitted entrant by declaration dated so and so, and under 9.5 we'll deport.
Thank you. Thank you very much.
Thank you, Lord.
I'm sorry, my name is Mr. Rick. I just on my conscience. In my case, I said that the date that the residence application was rejected was the 18th of February, but it's the 3rd of February, and I've repeated the 18th of February again. I think it's wrong.
3rd of
February. Sorry, short and small.
Well, the board is very grateful to council for their submissions in this case, and to those who have assisted council in the preparation of this appeal. The board will take time to consider what its judgment will be. The board will now adjourn.